Thank you. So, before I plunge into the detail of today's topic and jumping into constitutionalism and transformative constitutionalism directly, let me unpack what a constitution is. So, in brief, to know the constitution, its types, and the important uh, points which are relevant to understand the constitutionalism and the resultant transformative constitutionalism, which is really a need for the democratic society. So, regarding constitution, as to what the constitution is or what do you mean by the constitution, so, constitution is simply a contract between the governments and the governed. That is to follow the laws and will save your liberties, rights, etc. And it comprises the sets of the principles regarding the nature of governance, various organs of the state, and their functions, powers, and obligations. At the same time, it also comprises the rights and duties of the citizens in that constitution. Now, regarding the different types of the constitution, there are stable constitutions, there are fragile constitutions. Now, stable constitutions that, as Professor Rajkumar sir has just told you, that constitutions which have stood the test of times and survived the crisis. So we see that the U.S. Constitution is of 1789 and it is still working, and fragile constitutions that superseded by the dictators, military coup, etc. We see the examples of the Asian countries, African countries, and the Latin America that they are having more than one constitutions, and their constitutions are put under the category of the fragile constitutions. Then another type of the constitution is organizational constitutions that lays down the structure and functions of the state only, no more things, but only regarding the organization as to how the governance will work. Then another type of the constitution is known as the constitutionalist constitution. So in India, we have this type of the constitution. These type of the constitutions, they just lay down the structure, the functions, powers, authorities of the state organs, and the fundamental principles of the polity, the judicial machinery, their functions, powers, jurisdiction, then the rights and obligations of the citizens as well as the administrative structure. So these are all the parts of the constitutionalist constitution. But traditionally, the categorization which is more common, these are written and unwritten constitutions. So we find that US Constitution, Indian Constitution, these are the constitutions which are written constitutions. There are other countries also where we find that the constitution is written. But there are countries where we find that the constitution is not written. The great example you can take that is of the UK. In Britain, there is no written constitution. In Israel, in New Zealand, so they don't have any written constitution. But their governance is working on the basis of the principles, on the basis of the common law, on the basis of the decisions of the court. So they are working like that. Then another form of the constitution is a rigid and flexible constitution. So in amendment, where there is a rigidity, there is a difficulty to amend. So those are the constitutions which are said to be the rigid constitution. So we have the example of US, Canadian constitution, Australian constitution. Basically, the federal constitutions are usually called to be the rigid constitutions. Then another types of the constitution that we find is the federal and unitary constitution. So the federal constitutions are those constitutions where the power has been distributed among the center and the state, the union and the provinces. So these are called the federal constitutions. So great examples you can see that is of the US, Canada, of course, that is federal constitution. In Australia, they have the federal constitution, Malaysia, Germany, they are all having the federal constitution. And there are unitary constitutions also that the power is centered at the one place, that is the central government that works, and that there are certain countries which speaks about the unitary constitutions, that is Afghanistan, Bangladesh, Finland, then Sri Lanka, Singapore. So not many countries. There are many more nations where they have the unitary constitutions, and there are certain constitutions which is having a combination of various types of these constitutions. So after knowing as to what the constitution is, what are the different types of the constitution, it is important to proceed further as to the constitutionalism. So when we talk about the constitution, then constitution and constitutionalism have been defined in multiple ways, and it means different things to different people. You just take the example as Professor Upendra Bakshi points out that the imagery of constitution or the descriptions of the constitution and constitutionalism varies from the perspective of those who rule and those who are to be ruled. So it differs from the country to country, it differs from the person to person also. So one meaning of this term constitutionalism is that it denotes the mechanism which is in place in the political society, which is a result of the political and legal developments of that particular society. It also refers to the limitations subject to which the authority has to work, it has to exercise its function for the betterment of the citizens. So the basic thing is that the constitutionalism has both descriptive as well as prescriptive approaches. When we talk about the descriptive approach, then it refers mainly to the historical struggle of the people's right to get the constitutional recognition, and the developing of the governmental institutions, various organs of the state as essentials of the constitution. So this is how we see that the descriptive approach of the constitutionalism is based on the historical struggle of the persons of that particular country's concern. Then, if we talk about the perspective approach to the constitutionalism, it basically addresses what a constitutional should be. So, merely because a country has a constitution, it doesn't mean that it is having the constitutionalism also. For example, we can say that if a country with a dictatorship, where dictators' words are considered to be the law, so it can be said that they may have the constitution, but there is no constitutionalism. So constitutionalism is an idea that there are legal restraints on the exercise of the political authority. And constitutionalism is sometimes also regarded as a synonym to the limited government, to a minimal or the less government. So we can say that the guiding principles on the basis of which we can understand that what the constitutionalism is, that means that it is having the limits on the state action and conformity with the provisions of the constitution. So if we find that any constitution which is providing the limits of the state organs as to how they have to work, what they have to work, and then how they will conform with these provisions. If this exists, then there exists the constitutionalism. So this idea of constitutionalism, it is associated with basically the political theories that the government can and should be legally limited in its powers, and that its authorities or the legitimacy depends on the observation of those limitations or following of those limitations. So in general terms, constitutionalism seeks to prevent the arbitrary government. Arbitrary government, that means they have to follow the limits. They have not to apply their discretion arbitrarily. If they have to apply their discretion arbitrarily, that means they are going beyond the provisions which are there in the constitution. So the most salient feature of the constitutionalism can be said that it describes as well as it prescribes both the sources as well as the limits on the government power. So, to the extent of the power of a public authority and the limitations on that authority are the principles of the constitutionalism. So, in that way, we see that basically, when we are talking about the constitutionalism, then it speaks of both the limits on the power as well as the power itself, how it has to be conformed. So when we talk about the constitutionalism, then we see that there are constitutions which provides or which visualizes and the provisions in the constitution itself, that is of the checks and balances, and not to leave them to work arbitrarily. So these are few points where we can find that the constitutionalism exists in a country where there is a constitution, or where there is no constitution. Even then, if they are following those rules, if they are following the powers, then constitutionalism may be said to be in existence. It's not dependent only on the written constitution or unwritten constitution. In written constitution, constitutionalism may be there. In unwritten constitution, constitutionalism principles may be there. So how to proceed on these principles, or we can say how one can identify the extent or the limit in the constitution, or basically what is the supremacy of the constitution, why to follow the constitution. So we find these principles of the supremacy in different clauses in the constitutions of various countries. When we talk about the UK, then we find that there is no written constitution and the parliamentary supremacy is there. Parliament can make laws concerning anything, but no parliament can bind a future parliament. That is, it cannot pass a law that cannot be changed or reversed by a future parliament. So this is one thing with the UK, and a valid act of the parliament cannot be questioned by the court. So that's how we find that the parliamentary supremacy is there in UK. But with the passage of this Human Rights Act of 1998 and the establishment of the Supreme Court, the situation has been changed in UK. In USA, regarding supremacy, Article 6 of the US Constitution, that is known as the Supremacy Clause, which makes the Constitution, the federal laws, and the treaties as the supreme law of the land. Then Article 3 is also important, which deals with the judicial powers, which provides that the judicial powers of the United States shall vest with the Supreme Court and such other inferior courts as the Congress may from time to time ordain or establish. So this is Article 3 of the US Constitution. And we find that the concept of judicial supremacy received its recognition for the first time in US by a very celebrated case of Marbury versus Madison of 1803, when Chief Justice Marshall, John Marshall, when he invalidated that the law Judicature Act was invalid, and the American Congress, which has enacted that law, that is invalid. So in US, we see that the doctrine of judicial review has a firm root, and that's why we find that the judicial supremacy is very much applicable there in US. Now we see that in India, first and foremost feature is that the constitution is the supreme law of the land, known as the Suprema Lex also. So what we see is that the state organs, that is the legislature, executive, judiciary, they all are bound to function according to the Suprema Lex or the constitution. Their limits are laid down in the constitution itself. So they must act within those limits, and working within the specified limits is of course called the constitutional supremacy. So we find that in India, the constitution is supreme, and we find that constitutional supremacy resides in India. So how we find that the constitutional supremacy is there in India? So the principles of the constitutional supremacy, first of all, we find that the constitution is to be written and somewhat a rigid constitution. So we follow these provisions in our constitution, and if there is no rigidity in the constitution, the parliament would amend it easily and may dissolve its ideals. So we have the basic structure theory also, which has made it more rigid to amend the provisions which are coming within the category of the basic structure of the constitution. So though it's not totally rigid, the procedure for amending the constitution is not as rigid as it is in American or Australian constitution. But through the Supreme Court basic structure document, we find that the provision has to somewhat made rigid. So we find that the constitution can be amended, but the requirement for amending the constitutions tend to be a little bit difficult. Then another point for considering the constitutional supremacy is that the constitutional law must be different from the ordinary law. Ordinary law like right to education, right to information, then consumer protection. So these are the laws which have been enacted by the parliament. These are the ordinary laws. So it has to be a difference between the constitution. So constitutional law and ordinary law are different. And if there is any contradiction between the constitutional law and the ordinary law, the constitutional law will get the priority and it will prevail. So this is another point of understanding as to what is the constitutional supremacy is we find in the Constitution of India. Then another point is that since the constitutional law is supreme, so it cannot be challenged in the court of law. To check its validity, to check its legality or the wires, whether the constitution is constitutional or legal or not, like the ordinary law. So there was a case, Keshwanand Bharti, as I told you, and this question was there whether the constitutionality of the constitution can be challenged or not. And Justice Hegde and Justice Mukherjee, they observed that from the preamble, what we get that it is the people of this country who conferred this constitution on themselves. So this is what you find that the last words of the preamble, which says that and to give ourselves this constitution. So the constitution is being conferred by the people of the India, and the statement that the preamble that the people of this country conferred this constitution on themselves, it's not open for challenge before this court of law. And for the reason that its factual correctness cannot be taken into consideration or cannot be challenged in the court, because the court is the creature of the constitution. That is, the courts have been created by the provisions of the constitution. So they are also taking its validity and legality from the constitutional provisions. So how the courts can check the validity of the constitution? And further, the court said that because this was a case of 1973, so the court held that this constitution, we all know that it has been accepted and it is working for the last 23 years, and it is too late to decide on this question that the constitutional validity can be challenged or not. So we find that the constitutional supremacy means that no laws or action can violate the nation's constitution, and it is considered to be having the supremacy, which is viewed as a check on the power of the government. So we find that in India, these all principles are applicable and in existence, and that's why we find that constitutional supremacy exists within the constitutional provisions. Besides that, we find that some of the case laws where the court have also said that the constitution is supreme. Keshwanand Bharti case, it was a 13 judges bench case where the court has declared that the supremacy of the constitution is one of the cardinal feature or it's a part of the basic structure of the constitution. Then another case is Indira Nehru Gandhi versus Raj Narayan, where the court examined and explained that this supremacy of the constitution is in existence in the Indian constitution. And further, you see that Minerva Mills case, where the court said that the government, legislature, and judiciary, they are all bound by the constitution, and nobody is above or beyond the constitution. So again, this means that we have the constitutional supremacy in our country. So this is a very logical and natural meaning of the principles of the supremacy of the constitution, which we find that has been given by the Supreme Court in various constitutions. Now, if we talk about the idea of the constitutionalism, this is not very new idea. It has its roots in the human thoughts. Many natural law philosophers, they have promoted this idea in their writings. If you see Thomas Aquinas, Paine, Locke, Grotius, and Rousseau, then they all talked about, to some extent, of this constitutionalism principles. Then Magna Carta of 1215, this has also strengthened the view that the law is supreme. And then we find that in Indian constitution, where these principles of this constitutionalism are promoting in the various provisions of the constitution, then we find that the preamble, this is very inspiring and this reflects the hopes and aspirations of the people, like justice, equality, dignity, and fraternity. The preamble speaks of that. These are the principles relating to the constitutionalism. Then proceed further. If we see that the fundamental rights chapter, then we find that the life and liberty and all these rights, fundamental rights, they are there in the constitution. And we see that howsoever compelling necessities be there, but this right to life and liberty cannot be suspended. Though this has been inserted by 44th Amendment to the Constitution, because prior to that, we see that one of the important case, which is also said to be one of the dark case in the history of the Supreme Court, ADM Jabalpur, where this life and liberty was said to be conferred by the Constitution. So it's protected by the Constitution, conferred by the Constitution. So fundamental rights chapter, we see that the principles that promote the constitutionalism, then directive principles of the state policy. This is another area where we find that the provisions regarding social justice, economic justice. So all these have to be attained by the state action, by legislative action, and on that the state and this legislature, they are working. We are having the right to work, like this Manrega Act is there. So social to confer the social and economic justice. Various labor laws are reformative in nature. They are the outcome of these directive principles of the state policy. Then we find the independent judiciary with the power of judicial review. Article 13, particularly, we can have this for judicial review. Article 32, 226, 245, then 372, as I discussed that there is pre-constitutional law and post-constitutional law. So these all confers the power of on the judiciary to review the laws. And then this doctrine of the rule of law, that is another principle of the constitutionalism, though it's not clearly mentioned, or there is nothing like a text in the Constitution of India, but the courts have read this rule of law in Article 14 of the Constitution, which speaks of the equality, because as I told you that the historical background is also very important to understand the constitutionalism and the principles of the constitutionalism. So this Article 14 is very important, and then separation of power theory, that is also in existence in the provisions of the Constitution, not as rigid as in the US Constitution, but in India we find that. Then free elections to the legislatures and to the assemblies, to the parliament, and this is also there. The courts have come to deliver the judgments so that the elections may be free, right from Indira Nehru Gandhi, then to this Ram Babu Singh Thakur 2020 judgment, when these type of the free elections and the matters that the criminalization in politics may not be there. Then accountable and transparent government, democratic government. These are also some of the provisions which we find there in the Constitution. Then federalism. There are many case laws where the courts have said that the Constitution is federal constitution. And then we find that the decentralization of powers, that is also one of the aspects of the constitutionalism that is here in India. And though constitutional status has been given only 1992 onwards, that we have the village panchayat, the gram sabha, the municipality. So this is, we can say, a decentralization of the powers, and a three-tier system of the governance is working. So these are the principles of the constitutionalism. Now, another point which we should discuss regarding the constitutionalism is that how these norms of the constitutionalism work. So constitutionalism attempts to avoid any danger to the democracy by designing a mechanism and to determine that who can rule, how we can rule, and what is the purpose for ruling that. So the provisions regarding the ruling, that is all there in the Constitution. So we find that arbitrariness is not to be there. If there is any interference of the arbitrariness in the individual rights, in the people's rights, then we find that the constitutionalism will not be there, and one cannot say that the provisions of the constitutionalism are established there because the basic purpose is just to protect the rights of the individual. That is one of the principle of the constitutionalism. So it has to be seen that whether these norms are there or not, then we can find that the constitutionalism is working. So, in all, we can say the constitutionalism, which is an idea, that idea is just to have a limited government. The idea is to have a minimal interference with the government, working in the protection of the rights. They have to protect the rights and all the principles which we have just discussed. These are related to the constitutionalism. Now, when we talk about the transformative constitutionalism, then we see that the concept obviously encapsulates the two notions, the transformation and constitutionalism. And these two notions, which have been fused together and it has made a single notion, that is the transformative constitutionalism. So we find that there are three questions immediately which may come to your mind regarding the transformative constitutionalism. That what is transformation, what is constitutionalism, and what does transformative constitutionalism denote. So, as we have already discussed what is constitutionalism, then what is transformation? So, in simple terms, we can say that the transformation is something which is bringing about a change in a structured way. So, change for the betterment. It's not like that the minor changes are there that may be called transformation. The change should be in a structured way, change should be in a massive way. So, and that too for the betterment of the society. So, this is how we can mean the transformation. Otherwise, if we see the meaning of this transformative, then Webster Dictionary has defined the this transformative as causing or able to cause an important and lasting change in someone or something. So, this is how the transformative word has been defined in the Webster Dictionary. And the meaning of the transformation in juridical terms, this is always very contested term, and it is also very difficult to formulate what exactly transformative means. And we see that perhaps because of this, keeping the spirit of the transformation, that there is no single stable understanding of the transformative constitutionalism also. But anyhow, we see that the term transformative constitutionalism found its origin in this concept of the transformative constitutionalism in South Africa. So there was one US scholar, Carl Clare, who took this note of the concept and in his work titled The Legal Culture and Transformative Constitutionalism, which was published in 1998 in the South African Journal of Human Rights. So there he put for the first time that this term of transformative constitutionalism. So when we will be discussing the transformative constitutionalism as to what is the exact meaning and how we find this transformative constitutionalism, then we will find that in India we have, or the judiciary in India or the constitution itself was having some of the provisions which are related to the transformative constitutionalism. But this very phrase or this very term transformative constitutionalism was not used in India prior to that of Navtej Singh Johar judgment. So we find that this 1998 origin of the transformative constitutionalism by Clare, who was a US scholar who wrote this paper and published in the South African Journal of the Human Rights. Then this work of Clare that was taken note by the South African High Court Justice S.M. Benege in 2006, when he explained this transformative constitutionalism, that this is work for the judges and the other functionaries and institutions, that they have to play a role. As a role player, they have to work on this transformative constitutionalism, and the judges are the custodian of the constitutional values such as the human dignity, equality, freedom, and they also bear the obligation to ensure that the constitutional provisions are to be applied in such a way so that they may improve the quality of life of all the citizens, and that can also be free from any of the potential or danger to the person concerned or to their rights. They should not be infringed and violated. So, Justice Benege, he was of the opinion that this is the work of the judiciary and other organs of the state as a role player, that they have to take care of these things. Then exact definition, if we talk about as to what has been given by for transformative constitutionalism by Clare, who is said to be the originator, or from where we find this transformative constitutionalism has come into vogue. That is he wrote his work, that is as a long-term project of constitutional enactment, interpretation, and enforcement, committed to transforming a country's political and social institutions and power relationship in a democratic, participatory, and egalitarian direction. So this is how Clare has noted regarding transformative constitutionalism. So by this definition, what we find is that it doesn't work in isolation. It has some relation with the historical context, the political developments, the legal developments, so other developments of that society, on the basis of which we see that the constitutional enactments are there, the interpretation and enforcement procedure is to be taken care of. So, for the transformation, the history of the nation is very, very important. And there is one unpublished paper of Professor Upinder Bakshi titled Preliminary Notes on the Transformative Constitutionalism, that is of 2008, when he says that this distinctiveness of the historically specific moments of the transformative constitutionalism in three countries. So we have talked about the South Africa. We are talking about the Indian condition. There is one more country where this transformative constitutionalism has been also. We find that there is constitutionalism and transformative constitutionalism. So we find that in South Africa, the post-apartheid movement, that is having an historical impact on the transformation in the constitution. Then the post-authoritarian movement in Brazil and post-colonial movement in India. So on that basis, we find that that has the reflection on the working on the provisions of the constitution. And in all these three countries, we see that the vision of the future society was different because of their historical background. But the common element in all these countries was very, very taxing period, because we have seen the colonialism in India, and we have seen that how the Indians, they were being discriminated in every way, and there was inequality, discrimination, untouchability, gender inequality. So various evils were there, bonded labor. So all these evils were in existence. So we see that when the constitution was being drafted in India, so all these historical texts, these were all reflected in the provisions of the constitution. So similarly, when we see the South African constitution, so in South Africa, the constitution is seen as a historic bridge between the past and the future. And the evolution of this concept of the transformative constitutionalism is basically to address the issue of the poverty and inequality, because that was writ large in South Africa. So when they enacted their constitution, we find that the provisions which are addressing these issues, poverty and inequality, that found place in the US, in the South African constitution. And then when we come to India, we see that the constituent movement in India, they have seen there as a dialogue between past and future. As I told you, that untouchability, social discrimination, and all these were there. So we find that these provisions are the part of the Indian constitution. So if we go to see and check as to what are those transformative elements in the Indian constitution, then the very beginning of the constitution, we the people. So this phrase "we the people" in the Indian Constitution, this sets the agenda of the transformative constitutionalism, we should say. It gives a feel of the selfhood, we the people. It gives the feel of a selfhood, which is giving the opportunity and status to the people concerned, that who were facing the caste discrimination, religion, different ethnicity. So all these identities were not taken care with, and now the Constitution of the free India that speaks of the we the people. So we includes everyone, and this is the transformative element in the Indian Constitution. This is one. Then moving further, we find that in the fundamental rights, basically three rights I would like to emphasize upon. Those are designed to protect the individual against the action of the other private individual or private citizen. Article 15.2, if we talk about Article 15.2, that there shall not be any discrimination on the basis of the grounds they are given there in on the basis of sex, religion, place of birth, etc. So this is how we see that this is related in matters of access to and use of uh, we can say cinemas, use of the public parks, use of the public wells, and similarly in access to the other things which are made for the public, for the general public. So 15.2 is something which is protection under the fundamental rights chapter of the individual against another individual. Similarly, Article 17, which speaks of the untouchability, Article 23, which speaks of the, we can say, the prohibition of the bonded labor and prohibition of the moral trafficking, etc. So this also is related therewith. So when we talk about Article 15.2, that is very important because it speaks about that the citizen shall not suffer any disability for the use of the shops, use of the restaurants, use of the wells, use of the roads, and other public places on account of his belief that there is a that he belongs to a particular religion, a particular race, particular caste, particular sex or place of birth. So these are the points which are there in Article 15.2. So these three articles basically the Constitution, which is also considered to be giving the transformative element. Then we find that the state is also under this duty bound to provide that for particularly for these three articles that they have to work or they have to fulfill the positive obligation to protect the citizens' rights from the interference or from the encroachment of the society. Then we find that some of the important judgments which Indian courts have used in the Constitution and granted the protection of the rights against the state accesses. That is Article 32, that is a fundamental right to move to the court. That is also one of the very important and unique provision in the Constitution, which confers a transformative element. Then we find that the judiciary is also taking care of the rights of the person so that to make more and more inclusive society, more and more progressive society, so that the transformative constitutionalism may be seen in a more fair manner. So this is how the judiciary is working. Now, I would like to give one of the important case that is of the Delhi High Court, and that is Harsh Mandar versus Union of India, where the Delhi High Court has decriminalized the begging by declaring unconstitutional several provisions of the Anti-Beggary Act that was a colonial relic. We find that there are various laws which are very, very old, and these are the colonial laws still in existence. So, on this law of Anti-Beggary Act that was declared unconstitutional on Article 14, 19, 1A as well as under Article 21 of the Constitution. So, another case which is decided by the Supreme Court and where we find the term transformative constitutionalism has been written in the judgment for the first time, that is Navtesh Singh John versus Union of India, where we see that Section 377, that is again colonial law, that is of the Indian Penal Code, which criminalized the voluntary sexual intercourse and the same-sex individual. So the court, while doing so, it has declared that a great social document, which is almost revolutionary in its aim of transforming medieval hierarchical society into a modern egalitarian democracy. So, in that way, in a Singh Jawhar judgment case, Justice A.M. Khanvilkar, when he states that the whole idea of having a constitution is just to guide the nation towards a glorious, towards a magnificent future. And therefore, the purpose of having a constitution is to transform the society for the betterment of its people. And this objective is the fundamental pillar of the transformative constitutionalism. So we find that Justice A.M. Khanvilkar, he wrote his judgment in this Nafis Singh Johar case, and he says that this is important and this is to transform the society. And that's how we see that the transformative constitutionalism is considered to be one of the objectives of adopting a constitution itself. And the court in this case also, because there are different judgments given by various judges, then we see that Justice Deepak Mishra also highlighting as to what is the core of the transformative constitutionalism. So he was of the opinion that the rights that are guaranteed as a fundamental rights in the constitution, so those rights are very dynamic rights and timeless rights of liberty and equality. And it is going to be against the principles of the constitution if we give them the static interpretation without recognizing their transformative or evolving nature, because law cannot stay and remain static. Law has to change with the societal needs, and law is like a living law. So in that way, if the court gives the static interpretation to these terms of the liberty and the equality, then it is not going to deliver justice. And that's why we have to see as to what is the transformative and evolving nature. And in that way, the court, through Justice Deepak Mishra, also decided that the core transformative constitutionalism is just to give a liberal interpretation, and it has not to be static interpretation. So the argument doesn't lie in fact that the concepts which are underlying these rights change with the changing time, but the changing times illustrate and illuminate the concept of the underlying the said right. So that has to be changed with the society. This was the main purpose and objective while writing this judgment. Then we find there are other cases also where this transformative constitutionalism is seen. You see that Sabrimala case of the Supreme Court, in which the Supreme Court has struck down the prohibition on the entry of the women of certain or a particular age group, and the women who were in the menstruating age, and to enter in the Sabrimala temple in Kerala. And Justice D.Y. Chandrachud, in that case, he was of the opinion that a vision of the constitution as being transformative in character is like setting up the independent institutions of the governance, and to grant them or to this promise to fulfill the citizenship of those who were deprived till now and those who were marginalized. This is another form of the untouchability, so that we have abolished the untouchability in Article 17 of the Constitution, that is caste-based untouchability. But here, what we are finding is that this is a different type of the untouchability, wherein the women of this particular age, they are not allowed to enter the temple, and that's how this provision was struck down by the Supreme Court, that prohibits the entry of the women. So this was the Sabrimala case, you see. Then in Aadhaar judgment, another fundamental right to privacy that has been given the status of the fundamental right, and this is considered to be as a judgment which is transformative in nature. Then, considering the inequality in the services, there are lot many cases, but the latest judgment, that is in V.K. Pavitra 2020, this is V.K. Pavitra second case, where Justice Chandrachud and Justice U.U. Lalit, we have the provision in the Constitution at Article 16, which speaks about the the reservation provisions for the persons who are not adequately represented in the public service and public state employment. So, in this case, the judges, they were of the opinion that there is substantial evidence that the members of the Constituent Assembly recognized that the Indian society suffered from the structural inequality, and that the Constitution would serve as a transformative document to overcome them. So in this case, we find that this is also one of the method of overcoming the inequalities, and reservation for SCs, STs in the legislature, in the state services. These are there in the constitutional text, as well as the judiciary has also pronounced in favor of the judgment. So this is the judiciary is also towards the making this constitutionalism as a transformative constitutionalism. Then we see that this transformative constitutionalism in India, that was started basically after the post emergency. After emergency period, we see that there are different cases decided by the Supreme Court, where the ideals of the equality, liberty, and fraternity, they have begun developing by the judiciary. Because prior to that, we see that only Keshav Bharti was the case where the Supreme Court has given a different judgment. But otherwise, you see A.K. Gopalan case, ADM Jabalpur case. So these were the cases which were decided pre-emergency era. But post-emergency era, we see that a new system has been adopted by the judiciary in the name of delivering social justice. Then public interest litigation came in, which has liberalized the rule of the locus standi. So the Supreme Court has given the legitimacy and articulated all these jurisprudence of the public interest litigation. Justice P.N. Bhagwati, Justice Krishna, here you see that their judgments which allow the access to justice to all, because inequality and any type of the discrimination can be meted out only when the person has the right to access to the justice. So this is how these principles have been liberalized by the judiciary post-emergency era. And particularly we see in the field of the gender equality, then not only the Sabrimala case or this triple talaq case, and there were also various cases, be it Vishakha case, which was of 1996, because we see that in South Africa, this transformative constitutionalism for the first time got its origin in 1998. So our judiciary was doing this transformative judgments or progressive judgments prior to that also. So in Vishakha, you see that the court has taken the lead in the matters of the gender equality. Similarly, if you see D.K. Basu, then in the matters of the arrest, the courts have given the directions, and those directions were later on inserted in the criminal procedure code also by amendment. And similarly, the directions which were given in Vishakha case, law has been enacted in 2013. The court has gone to the extent of saying that till the law is not enacted on these points, then till then these guidelines will be followed as the law. So this is something which is coming under the transformative constitutionalism, that is just in order to bring the equality in the society. Now, again, you are witnessing that the cases relating to the Women's Permanent Commission in the Army, Babita Ponia's case of 2020, then the property rights of the daughter in the property, that is Vinita Sharma versus Rakesh Sharma of 2020 judgment. So these are the judgments which are laying towards, or which are leading towards a progressive impact, and which are said to be the transformative in nature. And then we find that the universal adult franchise, free and fair elections, voters' right to know. So this is all which is making a place in the polity of the nation. And this Ram Babu Singh Thakur case. So we have the right to know case, right from S.P. Gupta, then Indira Nehru Gandhi, and after that we find that there are many cases on this right to know, even to the extent that this right to know has emerged as right to information, and right to information, a specific act has been enacted by the parliament. So we see that the voters' right to know is also considered to be very, very important, right? When we talk about the free and fair election, when we talk about the universal adult franchise as one of the part of the constitutionalism. So in that way, the transformative constitutionalism is seen in 2002 in the Association for Democratic Rights when the court said that the voter has a right to know about the antecedents of the person who is contesting the election without knowing about his whereabouts, how the voter can give or how the voter can cast his vote. So this is how we see, and latestly in Ram Babu Singh Thakur case, the Supreme Court has gone to the extent of this, making this criminalization in politics. So how it has to be, abolished. To this, the court has given certain guidelines also, and which are to be followed. And then regarding this idea of secularism, which is said to be a basic structure of the constitution, then though it was not there initially in the constitution, was inserted by 42nd Amendment to the preamble, so we find that the secularism is also working. Then abolition of untouchability. You may be shocked to hear that in some of the uh, districts in Tamil Nadu, the shopkeepers, the tea vendors, they were also putting the pots, the cups, etc. That those persons who will be drinking the tea from that pots will not be used again by some other person on the basis of this untouchability. So Armugam survey case is very important for that. And right to equality, right to life. This 18 words article has come out with more than 30 rights with this right to life. So initially, what we see that right to life was interpreted that the life of the person, then later on personal liberty, then in right to privacy, both life and liberty were interpreted. But now the some of the high court, the Uttarakhand High Court and the Punjab and Haryana High Court, these courts have now been interpreting the person. No person shall be deprived of his life and the personal liberty except according to procedure established by law. So now this person is being interpreted by the judiciary in a very, very transformative manner so as to include the rivers, the words, etc. in the term person. So they are all having the right to life and liberty. So these were the judgments whereby we see that the transformative constitutionalism is seen through the judgments of the judiciary. And then the directive principles of the state policy, we see that various provisions under Part 4, those are being put so as to bring them in Part 3rd and to make a harmonious construction so that the rights may be given to the common man, to the citizen, to the people concerned, and vulnerable persons' rights, whether it be the child rights, the LGBT's rights, then older persons' rights, disabled rights. So all these we find that the judiciary is having a progressive or transformative interpretation of these provisions. Then if we go for the criminal justice system, then we find that the very liberal interpretation regarding the prisoners' rights have also been given by the Supreme Court, right from Sunil Batra, you see, and a lot many cases are there. Then in religion, region, language, and many more things, you find that the courts are performing their duty of interpretation in a liberal manner, and it's not a static interpretation. Because the tools that the judges they should adopt to breathe the life into the text of the constitution for its expansive reading of the fundamental rights. So these are known as the interpretive theories, and reading into the text written and post. This is how the interpretation has to be made, and the judiciary is working on that line. And we see that almost 70 years back, we have imposed this Constitution of India, and now the judiciary, by the procedure, by this principle or theory of reading doctrines, reading into the text of the Constitution, now they are giving a more progressive, a more transformative, and more developmental interpretation to ensure the equality and freedom, equality and freedom to all the persons. And the main object of the transformative constitutionalism is to rebuild the society on these new principles. And one of the important function of the constitution is just to enable the state to create the conditions of a just society. So, because the justice is the central notion of every constitution, and of course, it is the central notion of the transformative constitutionalism also. Because what's the purpose of law? Just to regulate the behavior in the society, and what is the purpose of the judiciary? That is just to deliver the justice. So, the basic notion or the central notion of this transformative constitutionalism is, of course, to deliver the justice. So, we find that the citizens' rights, which have been given the primacy by the judicial interpretation, by adopting the transformative constitutionalism, and their rights are being respected, the freedom have been granted, and their dignity has been respected. And the very purpose of the transformative constitutionalism, which we find in our country, is that the principles of the freedom, liberty, equality, and fraternity, these are all being seen in the judgments as well as in the provisions in the Constitution, because we see that Article 15 and 16 both were amended by 103rd Amendment, bringing Clause 6 to both the Articles 15.6 and 15 and 16.6. And that is basically for the EWS, that is economically weaker section, which was not there. So this is a part of the transformative constitutionalism, that to bring the equality in the society, the law has to be changed accordingly, and the amendment provisions are for that purpose only, which brings the transformation in the society as per the need, as per the demand of the society at a particular time. And you also may be aware about the book written by Professor Amrit Sen, this idea of justice, where he talked about the development as freedom. So this development, this transformation, this progression, or this progressive ideas, these are basically bringing the justice and the freedom to the person concerned. And then there is one more thing which is relevant here for the purpose of transformative constitutionalism. That is Justice Madan Lokur, the former judge of the Supreme Court of India. In one of his lecture, he told that this social justice is a vehicle for transformative constitutionalism. And there was a bench in the Supreme Court, which was established in 2015, which was headed by Justice Madan Lokur, known as the Social Justice Bench, which was trying to decide the cases to provide the social justice. So whatever name we can give it to as like a transformative constitutionalism or a progressive constitutionalism, the basic idea behind is just that this is to sow the seeds of the principles of freedom, liberty, equality, and fraternity. And this is how we see not only the judiciary, but the constitutional amendments are also in that line, so that this equality may be brought, the rights of the persons may be respected, their dignity may be respected. And that's how the judiciary is working, initially through social justice principles, later on public interest litigation, liberalizing the locus standi, and now it is in the name of the transformative constitutionalism. So to me, in jurisprudence, you all study that whether the judiciary or the judges make the law or judges declare the law. So here for constitutionalism and for transformative constitutionalism, we see that if it is a matter of the constitutionalism, judges declare the law, because whatever is there, they have to declare. But if it's a matter of transformative constitutionalism, judges do make the law. And because they have to bring the law in a contemporary manner, or which is relevant for the person concerned. So in transformative constitutionalism, they do make the law, and it is not only depending on the declaration. They follow the rules of the interpretive theories, which are very, very important, and they are not following the originalist theory or originalism of the Constitution, which speaks of just to speak about, just to pronounce what is there written in the text of the Constitution, but what is the requirement of the time, that is very important. And this is how transformative constitutionalism is in existence in India, and as well as the constitutionalism also has its or it's we can say provisions in the Constitution of India. So with these words, thank you very much.